Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Blazing Star Marketing Private Limited versus Income Tax Officer, pronounced by Kolkata Tribunal on the 20th of May 2026. The assessee, Blazing Star Marketing Private Limited, filed return for assessment year 2013-14 on the 23rd of December 2013 declaring total income of 2,27,100. Return processed under Section 143. 1. Jurisdictional Assessing Officer issued notice under Section 148 on the 30th of March 2021 based on investigation wing information regarding alleged credits of 3,24,90,000 from 7 entities. Assessee filed return on the 27th of April 2021. The case was assigned to Faceless Assessing Officer on the 10th of December 2021. Notices under Section 142(1) issued by NFAC on the 29th of December 2021 and the 17th of February 2022. Show cause notice cum draft assessment order issued on the 23rd of March 2022. Final assessment order under Section 147 read with Section 144B passed on the 30th of March 2022. Assessing income at 2,92,67,100 by making additions of 2,90,40,000. Assessee challenge assessment raising additional ground that NFAC lacked jurisdiction because Section 151A empowering faceless assessment of income escaping assessment was enacted with effect from the 1st of November 2020 but notified and made operative only on the 29th of March 2022 wide notification number 18 of 2022. Notices issued on the 29th of December 2021 and the 17th of February 2022 were before notification, hence proceedings without jurisdiction. ITAT admitted the additional ground as pure legal issue requiring no further verification. Relied on Supreme Court in Jute Corporation of India Limited vs CIT, 187 ITR 688, National Thermal Power Company Limited vs CIT, 229 ITR 383, and Calcutta High Court in PCIT vs Britannia Industries Limited, 396 ITR 677, allowing legal ground for first time before appellate authority. Tribunal examined timeline of Section 151A provision introduced by Taxation and Other Laws, Relaxation and Amendment of Certain Provisions, Act, 2020 with effect from the 1st of November 2020. However, actual operational notification bringing faceless assessment scheme for income escaping assessment into force was issued on the 29th of March 2022. NFAC issued first notice under Section 142(1) on the 29th of December 2021 before notification. Relying on coordinate bench decisions in MD Mahmood SK vs ITO, ITA number 2230 and 2229 Kolkata 2024, and Nabiul Industrial Metal Private Limited vs ITO, ITA number 1328 Kolkata 2024, Tribunal held that assessment framed under faceless mechanism was without jurisdiction and could not be sustained. Proceedings initiated before notification date were void ab initio. Tribunal did not delve into merits of additions including 1,87,50,000 on account of sale of unlisted investments and 1,2,90,000 on account of undisclosed receipts. Assessee argued investments were purchased in financial year 2007 to 2008 and accepted in scrutiny for assessment year 2008 to 2009. And sale price of 500 per share was realistic. However, jurisdictional defect was fatal and dispositive. Revenue argued that Section 151A was on statute book with effect from the 1st of November 2020, hence NFAC had jurisdiction. Tribunal rejected this, distinguishing between date of enactment and date of notification. Since Faceless scheme for income escaping assessment was notified only on the 29th of March 2022, any action taken before that date was void ab initio. Decision reinforces that exercise of statutory power must be backed by valid and operative legal provision at time of exercise. Reliance on coordinate bench decisions ensures consistency in Kolkata. ITAT clarifies that NFAC cannot assume jurisdiction under Section 151A merely because provision exists, it must be specifically notified and made effective. ITAT allowed appeal of Blazing Star Marketing Private Limited and quashed assessment order passed by NFAC for assessment year 2013-14. Decision underscores critical importance of operational notification for faceless assessment provisions under Section 151A. Procedural compliance with effective date of enabling provisions is mandatory. Any deviation renders entire assessment invalid. Question: what is the key legal issue decided in this case? Answer: the key issue is whether the National Faceless Assessment Center, NFAC, had jurisdiction to initiate faceless assessment proceedings under Section 151A before the provision was notified and made effective on the 29th of March 2022. The ITAT held that the proceedings were without jurisdiction and the assessment was quashed. Question: on what basis did the ITAT quash the assessment? Answer: the ITAT relied on the fact that Section 151A was notified only on the 29th of March 2022, but the NFAC had issued notices under Section 142(1) on the 29th of December 2021 and the 17th of February 2022, well before the notification. Since the faceless assessment scheme was not in force at that time, the entire assessment was invalid. Question: did the ITAT examine the merits of the additions made by the AO? Answer: number the tribunal did not go into the merits of the additions, sale of investments and undisclosed receipts, because the jurisdictional issue was dispositive. Once the assessment was found to be without jurisdiction, it was quashed entirely without addressing the factual aspects. Question: which earlier decisions were relied upon by the ITAT? Answer: the ITAT relied on the coordinate bench decisions in MD Mahmood SK vs ITO, ITA number 2230 and 2229 Kolkata 2024 dated the 4th of March 2025, and Nabul Industrial Metal Private Limited vs ITO, ITA number 1328 Kolkata 2024 dated the 15th of October 2024, both of which had similarly quashed assessments where proceedings were initiated before the notification of Section 151A. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, taxpundit.org. If you have any questions, feel free to write to us at taxpundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.